Hello everybody, I'm continuing my introduction to tort. So looking at what damage is actionable, as in which one gives rise to a cause of action you can sue somebody for. So it's a bit tricky here because there's a lot of case law to do with it. And there's a hierarchy of interests which are protected under tort. Physical injury is the one that's most strongly protected. There's damage to property, there's also your psychiatric health, and there are economic losses. There are different kinds of injury or loss which tort recognises, not those four categories listed herein before. And some of these relate specifically to negligence actions. For instance, there's breach of privacy, there's misuse of private data, and these can engender particular forms of damage, especially after the data protection regulation that came into force in May 2018. That's pursuant to a European Union law, but I know that Brexit has occurred, but nevertheless, all the EU law remains on the statute book in the UK unless it's specifically repealed, and very little of it has been repealed. And breaches of data protection can result in a fine of up to 2% of the annual income of the organisation, or indeed the individual that breaches it. However, there would have to be several massive breaches for them to fine you that much. The authorities are understanding, they realise it's a tricky and new area, so they'll give you several warnings as minor fines, but they're going to become less sympathetic the longer the law is extant, the more time you've had to familiarise yourself with it. Anyway, so, okay, there are other, there's this hierarchy of interest which I adumbrated, and there are some general principles, and these are applicable by the courts. They use these to help them decide whether or not to acknowledge that an injury is recognisable in tort. So here are some of the principles. Loss or injury arising from natural causes are usually beyond the scope of tort. And now that seems to be blatant, but that's because we're talking about tortious damage. There's a very good article by Stapleton about this, Disease and the Compensation Debate, 1986. It shows how non-traumatic injuries, let's say diseases, are unlikely to be compensated in tort. And that's not because these things are specifically prohibited from recovery, but because non-traumatic injuries, they go against the clear concept of tort, which is mostly based on trying to tell apart man-made causes and natural causes, and it's increasingly difficult to disentangle them. So if an injury is said to come from a natural cause, that's a disease and not an accident, then the principle is that the losses usually lie where they fall, with the individual, unless there's an overriding reason to shift the burden of the loss. And so these losses are usually irrecoverable. However, traumatic injuries, as in those that we can say happened at a particular moment, particular place, and all the rest of it, those usually do receive compensation. Okay, so here's an important case. There's Jobling and Associated Dairies Limited, 1981. The defendants were found liable in negligence because the claimant, or the plaintiff as I said back then, he suffered a back injury whilst at work, and that reduced his ability to earn 50%. 3 years later, before the trial of negligence action, then a disease came along and damaged his spine, rendering him completely incapable of work. Now, the second event was one which occurred naturally, and therefore the House of Lords, which is the Supreme Court at the time, ruled the defendant could only get back the value of his earning capacity before the onset of that disease. Now, there's another principle that injuries or losses which are consequent on a particular trauma, such as a car crash or falling over because someone didn't have the lights working or whatever. These are types of injuries where tort privileges, these ones above other ones, because these injuries are usually compensated in tort because the courts see them as something which merits compensation. Now, there's another principle that the losses that are compensated from other categories of law are unlikely to be compensated in tort, and even they do receive compensation, it's usually less than otherwise. For instance, someone who's suffered nothing except financial loss because of someone else's wrongful action or negligence will probably not be able to prove a claim in tort, and that's because contract law is seen as the area that should deal with that. And there are other types of injury which are going to damage many people, and these are very tricky when it comes to inaction, because it's only when the the damage is on a clearly defined limited class of people. For example, Alcock against Chief Constable of South Yorkshire 1992. That relates to the Hillsborough disaster of 1989. The Sheffield Wednesday and the Liverpool fans in that football stadium, and lots of people asphyxiated by the crush. Okay, so coming on to personal injury. Now, this is the biggest and the major category, and it's highly complicated. So personal injury can be subdivided into three subcategories. There's traumatic physical injuries, such as wounding yourself in an accident, being born with a congenital disability, pain and suffering that are coming from wrongful births, but it's questionable whether giving birth is an injury. Especially volenti non fitinuria, as the woman, well, unless it's rape, has consented to the act which has led to the conception and has consented to continue the pregnancy which has led to parturition. So there are also non-traumatic physical injuries, disease, or indeed wrongful life, a baby being born when the parents were hoping to be sterilised, and that's highly contentious, the very concept of wrongful life. There are also psychological harm or nervous shock. Anyway, so what sort of damage is excluded from the ambit of negligence? So tort says that there's to be compensation for all kinds of loss or harm. There are some types of loss or harm which cannot be recovered under tort. So personal injury and other losses which are due to a traumatic event are regarded as worthy of compensation, and damages in tort will usually be granted. For instance, injuries arising from motor accidents, there's Nettleship and Weston, 1971, and the person had his kneecap broken, or there's medical mishaps, Politho against City and Hackney Health Authority, 1998, and there was a death of a child, and was that because the doctor didn't come to attend? There are injuries due to falling over on a premises, something Wheat and Lacon, 1966, is because the staircase was unsafe, and that results in somebody's death. There are situations where losses or injuries suffered are regarded as actionable. There's actionable damage, and so an action can be sustained in tort. So that's because there's a duty of care. If you owe a duty of care and you fail in your duty of care and injury results, then you're liable. So the law says it has to treat different claims of courts differently according to the circumstances. The courts, they also consider the resources available, and they also have to think about the economics of all this, of different types of defendant when they're awarding damages. So McFarlane against Tayside Health Board, 1999, was a case from Scotland. Here a child was born, and the parents were not allowed to recover the cost of raising their child. And this is what a scholar of jurisprudence, Tony Weir, wrote about it. Making a public body pay damages reduces its ability to perform its services to the public. The hospital trusts, which have to pay the damages out of their normal budget, have less money available for the cure of the sick. It's therefore nothing short of outrageous that for many years, until stopped by the House of Lords, the court made them pay the cost of bringing up a perfectly healthy child born as a result of their negligence. It was robbing sick Paul to pay healthy Peterkin. Pause there. So because they're paying these parents the cost of bringing up this child, therefore the hospital can't afford medicines, equipment, doctors and nurses that they need to save lives. You're bringing up your child, well, we don't regard that as suffering. So this was McFarlane. There was a couple. They already had 4 children. They didn't wish to have any further children. So Mr. McFarlane underwent a vasectomy. So he's still capable of intercourse, but he was not going to be ejaculating sperm. The semen coming out would not fertilise his good wife. So the operation was unsuccessful, but the NHS didn't realise that. Then the man had to produce a semen sample, which was tested to determine whether there was any sperm in that, and the doctor wrongly told Mr. McFarlane that no sperm was found. Therefore, Mr. McFarlane and his wife believed they could dispense with contraception, and they carried on having intercourse, as a result of which an infant was conceived. So then Mrs. McFarlane then gave birth to her child. So she was given £10,000 in damages for the pain and distress of pregnancy. Though they were told that vasectomies are not an absolute guarantee, and there are obviously different ways you can do vasectomies. Vasectomies are sometimes reversible. There is a small chance of failure, so no, we're not promising you an ideal outcome. It could fail. Now you could use belt and braces. You could have a vasectomy and persist in using contraception. So, and then they wanted a further £100,000 for the cost of raising their daughter until she reached 18. Now the judges in the House of Lords all said no, that is bunkum. They threw it out because bringing up a healthy child is not considered to be a loss. Anyway, so Lord Slynn said that bringing up a child due to failed sterilisation is a category of pure economic loss, and remember, that is irrecoverable in tort. So the costs arising from the mother's pain and discomfort in pregnancy and childbirth, that's different. Anyway, so the McFarlane principle cannot be gone away from. We can't get too far from that. Because even if the child is born with a serious disability. For example, Rees against Darlington Memorial Hospital NHS Trust, 2004. The child was born visually impaired. The parent was visually impaired and didn't want any more children because she felt she was scarcely capable of raising a child. So she had sterilisation, and this went badly. The defendant, as in the hospital performing it, said, yes, we were negligent. And the woman fell pregnant and she was delivered of a bonny baby boy. So there was a decision in McFarlane said that none of the cost of raising the child could be brought up because the parents were healthy and so was the infant. But this was different. The negligently performed sterilisation. The Court of Appeal said there's a difference between a parent who's badly disabled and a parent who's able-bodied, because the able-bodied parent is perfectly capable of raising a child. Anyway, this disabled woman, she needed assistance in raising her son. So the House of Lords decided 4-3 that there was still going to be no principle, no exception to the principle laid down in McFarlane, even though the parent was seriously disabled. So the House of Lords overruled the Court of Appeal, because a child is regarded as a boon and not as a curse. All right, so that's enough for the moment. Toodaloo.